Hello, everyone, and welcome to our Lunch and Learn series. My name is Giza Lopez. I'm the Executive Director of the New York State Youth Justice Institute. I want to start by thanking each of you for joining us today. This is the first YJI Lunch and Learn webinar of 2021. If this is your first time joining us, welcome. If you've been with us before, welcome back. Our gratitude also goes to our partners at the New York State Division of Criminal Justice Services, the New York State Office of Children and Family Services, the University at Albany, and the New York State Juvenile Justice Advisory Group for all of their support. A special shout out to the researchers from both DCJS and OCFS who are joining us here today. It is my absolute pleasure to host Dr. Sarah Lageson today. I am sure today's discussion will be wonderful, and it may leave you wanting to learn a little bit more about Dr. Lageson's work. If so, I highly recommend her stunning book, Digital Punishment, published recently by Oxford University Press. It is wonderful to have you here, Sarah. Brian Rainey will kick us off with a proper introduction to Dr. Lageson. And meanwhile, I'd like to invite you to introduce yourself and say hello in the chat box. Take it away, Brian.
Hello, everybody, and welcome to the Youth Justice Institute's Lunch and Learn webinar series. As Dr. Lopez said, my name is Brian Rainey, and I'm a graduate research assistant and YJI fellow with the YJI. The goals of this webinar series are to, 1, act as a source for cutting-edge research on juvenile justice issues, 2, to provide information in an engaging and thought-provoking format, and 3, to bring together scholars and practitioners from various fields to explore these issues. I have one housekeeping item today. In the calendar invitation that I sent out on Friday and this morning, we included a link to a web page showing how to access all of the features used today. Please reference this resource if you're having any difficulty with these features. We highly encourage you to submit your questions as they come up. There will be points throughout the presentation today that are designated for answering audience questions, and we'll have a Q&A portion at the end. We ask that you put all of your questions for Sarah into the Q&A section, and comments can also be submitted in the chat section. And now that that housekeeping item is done, I think we're ready to hear from an expert in punishment, criminal records, and technology. So Dr. Sarah Lageson is an assistant professor in the School of Criminal Justice at Rutgers University Newark. Dr. Lageson studies criminal law, privacy, surveillance, and tech, and her research examines the growth of online crime data, mugshots, and criminal records that create new forms of quote-unquote digital punishment. She is a grant recipient of the National Institute of Justice New Investigator Early Career Award for her study of criminal records, and is a 2020-2021 Access to Justice Scholar at the American Bar Foundation. Her research has been published in peer-reviewed journals including Criminology, Law and Society Review, Law and Social Inquiry, Punishment and Society, and the British Journal of Criminology. Her book, Digital Punishment, Privacy, Stigma, and the Harms of Data-Driven Criminal Justice, was published in 2020 by Oxford University Press. So, without further ado, Dr. Sarah Lageson.
Thank you so much, Brian, and thank you to everybody for this wonderful institute from YJI. I'm very excited to be here and look forward to our conversation. I'm going to go ahead and share my screen. I prepared about 25-30 minutes of notes here, and then we're going to open it up. So please feel free to ask lots of questions, and hopefully this will be helpful to the very important work that you're doing. So yes, my name is Sarah. I work at Rutgers, and here is the cover of my book that came out this past summer. And, you know, big picture, digital punishment is essentially referring to the consequences of our data-driven criminal legal operations. So you sort of have this big push in every sector, including criminal justice, to collect, aggregate, disseminate, and merge data to be more efficient, sometimes to be more transparent. But in the US, we have a very permissive set of public records laws that sort of interact with these advances in technology to honestly create permanent stigmatization and discrimination against potentially millions of people every single year. And as we'll show you in the talk today, as these data are disseminated by government, they're picked up by private agencies, and they are disseminated across many different platforms. So I'll start with a couple anecdotes because I think that it sort of helps describe the contours of this broad idea of digital punishment. So the past few years, I've been doing a lot of research in New Jersey, and New Jersey is very notable for having pretty expansive criminal record expungement laws, and most recently adopting Clean Slate, which is an automated form of criminal record sealing or criminal record expungement. And it's gotten a lot of positive press, as you can see on these two screenshots here from some local news coverage. But I'll tell you about three people in a study that I have been conducting in New Jersey. First, I'll tell you about Cindy, who was arrested in 2010 for attempting to fill a fake prescription at a pharmacy. She was coping with addiction, and as soon as she gave the pharmacist this prescription, the police were called. The pharmacist declined to fill the prescription, so she left the pharmacy, got in her car, and as she left the parking lot, the police were arriving, and she got in a little fender bender with the police car. However, when she was arrested and charged with attempted murder and aggravated assault of a police officer because of a car accident. So you see sort of this situation that escalated very, very quickly, and some maybe overzealous charges and prosecution. Long story short, by the time she went and saw the judge, she was convicted only of the forgery charge. She did spend some time incarcerated, and when she was released, she entered the job market and did a Google search for her name. And of course, the first thing that came up was her mugshot with the headline, "Attempted Murder of a Police Officer." And so she said, look, this thing happened, but this is just such a misleading characterization of this criminal justice event that happened in my life. And yet it's sort of become her master identity online. She can't change or alter or remove her search results. Or Carl is a young man in my study who was convicted of a gun charge in 2005. He completed 2 years of probation. 10 years later, he was legally eligible to have his record expunged under New Jersey law. In fact, he needed to have his record expunged to keep his job, which was at a local school. However, when he tried to file for his petition, there was a missing court record, and there was a big confusion where the judge had one set of data, different police departments and different courts across the state had different sets of data, and Carl's expungement petition kept getting rejected. And so it turned out, after he was able to get a lawyer that would do pro bono work on his behalf and a couple informal phone calls to different offices, that a family court matter had accidentally been recorded into the adult criminal justice system data. So the judge was seeing these stalking charges. No one could make sense of them. It turned out it was just a data error. But for Carl, he was driving from courthouse to courthouse saying, I don't even know what is on my criminal record at this point. I thought it was simple, and now it's become much more complicated. Or there's Alan, who was arrested at his home for failing to appear in court. This was an administrative problem. His court summons being sent to his prior address, and he spent a weekend in jail. His first time being arrested, it was a very disorienting, kind of confusing situation because he really had no idea that he had a warrant out for his arrest. He goes and sees the judge. They clear up the misunderstanding, and the judge tells him, you can go and file for an automatic expungement. You can have this arrest sealed. Of course, though, when he got home after filing his paperwork, he found to his dismay that his name remained on an online jail roster, which was then replicated across a lot of private websites. And he also noticed that when he tried to contact one website to have it taken down, his information was shared to even more websites, and he was just being continually harassed about these reputation management sites just for this one arrest that should have been expunged. And for this audience, I just want to be mindful that this is not just a problem in the adult system. There's excellent research that shows that the juvenile justice system, while often supposed to be confidential, records are supposed to be sealed, there can often be disclosures that are sort of either accidental or inadvertent or some sort of oversight. I would direct your attention to a debate that's been happening in Washington state for almost the past decade about records that were meant to be sealed that were released, and sort of the utter lack of recourse that people have once that happens. So big picture, digital punishment. It's a disordered type of criminal punishment because it's not prescribed by the court. It's a different type of collateral consequence where the criminal record itself can document all sorts of different activity, not just a conviction. Everything from a police stop, an arrest, to a conviction that happened a long time ago and perhaps didn't show up in the public record or it didn't show up on the internet for a while, then suddenly did after a new set of data becomes available. There's the public form of records maintained by the government, and then there's private forms of records that are maintained by companies. Data is always decontextualized and almost immediately stale. Criminal cases change over time. Records can be sealed, charges can be downgraded. But when data is taken as a grab, as a cross-section in time, we really only get information about that specific moment. And then once it's disseminated, we lack those important updates. This is commodified data. Though it's released in the public under the guise of public records laws or transparency laws, private companies benefit enormously by this cheap digital resource. So this is big data. This is data that's mined, scraped, merged with other types of public and private records, and then resold on the data commodities market. This is surveilling. Once someone is marked by digital punishment, the record seems to pop up everywhere. It's unpredictable. One website will turn up while another one suddenly disappears, might come up again a couple of years later. And there's lots of sort of terms that academics have applied to this sort of feeling of digital surveillance. Big data blacklisting, the idea that you can be accused of something without a real sense of reasonable suspicion or probable cause. Labeling theory, the idea that we assign risk to people, that we use all this data to actually calculate risk assessment scores, leading to forms of algorithmic injustice. And it's disparate. So all of the problems that exist, the systemic problems in the justice system, are replicated and exacerbated in the digital sphere. And not only is this about who is more likely to be stopped by police or who's more likely to be able to pay for an attorney that might help you leverage some privacy or even have your charges downgraded. This is also about the way that privacy capital is structured by social class, by race, by age, by your comfort with technology. So we get into the situation where the people that are sort of, the least likely to be arrested in the first place are also the most likely to be able to manage their digital identity. So there's a lot of variation among states as well. So I wanted to share this great chart from the JLC. They are always updating these confidentiality and expungement scores, just so you can get a sense of how uneven states are in the way that they think about how to release records. And I just want to give a quick note about my methods here. So I'm going to go through about 10 slides from a set of interrelated studies I've been working on the past 4 or 5 years. So first, I worked with a team to understand sort of what are the public policy directives that states use to decide whether or not to disclose various types of criminal justice information. And then we actually coded and looked at the websites themselves to see what information different types of agencies affirmatively post online. So the 200 laws and 200 websites refers to 4 different types of criminal justice data produced in every state. So it's police arrest data, it's criminal court data, it's correctional data, and then we also looked at the state repository, sort of the kind of the rap sheet data. This was complemented by fieldwork and interviews through relationships with several legal aid sites. And I did interviews both with people who are impacted by this and then the people who either maintain these data, who publish websites that report this kind of data, that run background checking companies. So kind of both sides of the equation. The National Institutes of Justice study that Brian mentioned when he was introducing me looked at sort of the way that records disseminate across platforms. So I'll share some very early results there to show how once a record originates in the public sector, how it can sort of change its form as it replicates across the private sector. And then a subset of those participants have been going through the expungement process in New Jersey. So I've been following them for the past 3 years to kind of see how that process has unfolded. Now, the important thing to remember is that all criminal justice records do start within the state, right? So first we have law enforcement records, which are often regulated through public records law and exist to notify people about what law enforcement is up to, sort of the classic transparency rationale. However, we don't get a lot of data about the police when we see these records. We often get a lot more information about the people that police have decided to arrest. Courts in general are bound by sort of a constitutional openness. So sort of this presumption that all court records will be available to the public. And states really had to kind of puzzle through this 20, 30 years ago once records went digital, right? So The rationale that's been guiding most courts until maybe very recently has been, if a person can come access it in real life at the courthouse, well, then they should be able to access it on the internet as well, which has created a lot of headaches for courts as their websites get mobbed by all sorts of private actors who wish to take that data. But that is sort of the underlying rationale for why court records exist online. Correctional records, prisons are a place where it can be very hard to get data as an outsider. It can be hard to visit. They can be hard to access. So every single state in the US runs a website where you can look up who's currently incarcerated. Some states have lots of detail, including an incarcerated person's height, weight, skin tone, the tattoos that they have, their eye color, their last known address. There's sort of increasing levels of kind of community level surveillance that can be done by accessing the correctional records online. And finally, criminal record repositories. This is sort of the centralized agency in most states. This is under the guise of the state police that takes all the data from different police departments and different courts, compiles it together into a rap sheet, and that rap sheet can also be utilized for national background checks through the FBI. So put differently, where do criminal records start? Well, often by an arrest, you're added to an arrest roster. Those arrest rosters can be crawled by third parties. They can be reposted to different types of websites. And then once posted to a website, they're indexed by Google so that if you search for somebody's name, keeping in mind that most people don't have that many Google search results, right? So if you've been arrested, it tends to pop up first. So that's being indexed into your Google search results. The other main origin point is at the court, where someone is charged with a crime that is sort of turned into a data set through the aggregation of the court docket. Those records are often sold to private companies directly by the courts, merged with other types of public records, such as address records, phone records, sometimes merged in reports with social media records, and those are resold on the private market as well. So a little bit of policy background. There's a public records designation argument, I think, that people think of for criminal records in general, but if you look a little closer, we actually only give that public records classification to often pre-conviction records, so law enforcement and criminal court records. State criminal records or rap sheets in 25 states or 50% of the US are actually under a different set of law. So this is either the penal code or some sort of administrative regulation for the state police. And in those 50% of states, rap sheets are not in the public record. You cannot just look up somebody's rap sheet. You need to have their fingerprints or their consent. And when you get the rap sheet, it will not have dismissals on it. It won't have arrests that didn't lead to charges. So we treat different types of records very differently based on the originating agency, which has big implications for people whose arrest never led to charges or a conviction. And I will say, I'm working on updating this data with my colleague Juan Sandoval at UC Irvine right now. And we have seen, I think 5 states now, where law enforcement has changed their statutory language around the public records designation. So it does seem that we're starting to see an evolution towards more privacy rights for people before their criminal convictions. And this slide here just sort of lays out that kind of unevenness again, where you see the public records statutes, really focused on that pre-conviction or early part of the process data. And then all the way on the right side of your screen, these criminal justice statutes governing access to state criminal records. And I think that's important because what you often see in the statutory language there is a sense of the rehabilitation effects, the sense of putting a limit to punishment, the idea that there is a public interest in rap sheets, but it's only for certain types of information and it can only go so far. So thinking about agency practices, criminal justice agencies, there's thousands of them across the country that are tasked with modernizing their record keeping, but not giving enough resources to do it, right? So not being able to develop their own technologies, having to rely on third-party software, private vendors selling different types of technologies to them that often can lead to online jail rosters being published without a lot of foresight. At the same time, agencies are responding to community demands for oversight and Freedom of Information Act requests, and then trying to work together to try to figure out how to synthesize and coordinate data across agencies. So it's a very difficult position, I think, for agencies to make all these decisions when even within one state, there can be great variation on how these decisions are made. So we have this kind of moment where these data systems that really evolved first and foremost for internal management and investigations and sort of like tracking people in the system, being transformed into this valuable data commodity. And because it's this unregulated private market, the data are often outdated or misleading and widely available to the public. There's a lot of legal precedent here. So the First Amendment protects republication of information obtained from a publicly accessible source. So if the government makes it publicly available, you have free reign to repost it. And if you don't like it, or if the government maybe erred in releasing it, you still can't sue for damages. You can't sue the newspaper for damages because, again, the government made it available first. This applies to records of arrests that didn't lead to charges that are even later sealed or expunged, because as the court reasoned in this Martin v. Hearst Corporation case, the historical accuracy of your arrest still exists. You were arrested. That is a newsworthy event. There's a First Amendment protection for publishing that. And the regulation that we do have really covers consumer reporting agencies. So this is companies that will sell a background check that are complying with different types of data accuracy and data integrity regulations so that an employer can safely use that background check and avoid liability. This does not apply to Google search results. This doesn't apply to all those websites that pop up when you search your name and it says, Sarah Lageson arrested. Those are people search websites. They've evaded Fair Credit Reporting Act regulation. And the volume is considerable. These are estimates I came up with Juan Sandoval again and with Liz Webster, who's at Loyola Chicago. And if you just look at the column all the way to the right, you can see how quickly the number of records that are produced by local agencies each year just balloons. And the N here, and the percent here, are referring to the number of states that make this available on their website. So this was the content analysis that we did of the 200 websites. So as I said, 50 states, all 50 states put their prison inmate rosters online. You see the mugshots are about 42%, arrest records 82%. And then the rap sheets, the 58% refers to states who make it available to the public, but at a cost. So there's some states where you have to actually pay for the rap sheet. Almost all states, actually. Only Minnesota is giving away rap sheets on their website for free. I'd be remiss not to talk about the public benefits. I think that's important. So there's been great advances in the ability to do clean investigations, to do bigger, faster investigations, to do smart prosecution. Really importantly, to finally give victims a sense of what's going on with the case of the perpetrator. Vine is a website that lets victims get notifications if the person that hurt them is being transferred between facilities or being released. Of course, we want government oversight. We want the media and regular people to be able to know what's going on with the justice system. The internet's also changed the way that we can leverage accusations. If you have tried legal avenues, you've tried other sorts of organized extra-legal or institutional avenues and haven't seen justice. The Me Too movement is rooted in sort of people having the ability to publicize transgressions. And of course, when we're thinking about police misconduct, I don't think we'd have any of the conversations that we're having now about changing policing if it weren't for the ability to record what's happening. But there's many bad actors that take this philosophy and use it for their own ends. So these public record search services are always advertising these huge numbers of criminal records. They report much higher numbers of criminal records than the government even says exists. So these are free criminal records, instant felony searches. These are merged with these reputation reports where you can actually find out, what your score is based on your criminal record and your Facebook profile. Mugshot websites we could talk about for a long time, but they're extortion schemes. They charge people money and to have their photos removed only to repost the photo, and state laws to combat this have not been very effective. There's now this new industry of mugshot erasing services. Court records have shown, unfortunately, sometimes the same person who owns the mugshot publishing website also owns the mugshot unpublishing service. So they really are making money on both ends of this. And I put another screenshot from the Washington State case here where, we have to think about how how little the state benefits from compared to how much these private companies benefit. These companies are scraping up public records at little or no cost and selling them for much more. And here's some of the language that these private services use to kind of advertise how many records they have and how much better they are at maintaining records than the state itself. And part of this is that, we have an American culture that wants to see these data. So here's some screenshots from Instant Checkmate. People are saying, I tried this, it was so revealing, I was shocked, I needed to do a background check and someone my child was starting to date. Very understandable modern anxieties when we meet people on the internet and we want to know who they are. When you use Instant Checkmate, you get this warning sign. There's a couple important things here. The first is that they make a claim on the bottom of this notice that they do not comply with the Fair Credit Reporting Act. So as a user, you are not to use the information that you learn through Instant Checkmate to make some sort of hiring decision or decision on who to rent an apartment to. But we don't know what people use this kind of information for. There's also interesting in the middle of the notice, it says, learning the truth about the history of your family and friends can be shocking, so please be cautious. And I think that really just ties into this sort of anxiety that we have, that we never know if we're getting all the information. This is sort of what clickbait is kind of based on, the psychological fear of missing out. And we apply this to other people. We kind of have become to this moment where we think we're an irresponsible person if we're not conducting the background check. And these websites completely tap into that anxiety. When you look behind these websites, though, and the people that are running them, it's a very different scene, right? So this is the company, the control group that owns Instant Checkmate. And they are a very sleek technology company. They sell themselves to their own potential employees as, having Nerf darts, and they're coding, and they're in California and they've got surfboards. And I draw this contrast to your attention just because I think that there's this moment where a lot of the logics of the technology sector are being put into criminal justice. And in the realm of criminal records, particularly, companies are telling us that they're more objective, they're more data-driven, they're more transparent, and they can do this better. The problem for the person in the record, though, is that they don't have a lot of ability to interact with these private companies and ask for data to be accurate or ask for it to be updated if they got an expungement. So it really it kind of makes the data move into a whole different realm that is well outside of the control of the people that are ensnared in it. Here, this is a graph of our newest study, and this is sort of rough data that we're still working through. But the big takeaway here is that we had a lot of people in 2 different states. We looked at their private facing rap sheets that they obtained from the state police. They shared with the researchers. So we've got nearly 5,000 criminal history events in these state rap sheets, consisting of both arrests and charges. And then we ran people's names through a bunch of different databases, through 3 different private FCRA compliant data sources, through VicTig, through the state court website, through Instant Checkmate, and then through a couple mugshot websites. And those other sources were often reporting all sorts of information that didn't appear in the state rap sheet. So sometimes this is just data error. This is that a company that's reporting it doesn't understand how that local jurisdiction organizes their data, or how they label different types of offenses, how they label a probation violation or some sort of deferred adjudication. Things get messy. So big picture, what we're learning, our first kind of takeaway was that 40% of the criminal records that we could access in the public sphere didn't originate in the rap sheet. They originated in these other sources. So the data quality is just really, really troubling. If you could do a really deep dive on one person, this is a single burglary conviction for a person in our study. And if you look on the left, this is how that burglary charge kind of worked its way through the system as reflected in this private facing rap sheet. So there's an arrest for burglary, there's a conviction for the burglary, and then 3 years later, there's a probation violation and a second probation violation. That's how you read it if you have access to this person's rap sheet, but that's not in the public record. If you look at the public record, we see that the arrest shows up as a mugshot. It shows up on the court website. That makes sense so far. Then we see the convictions showing up on 3 different sources. That makes sense. When you look to the bottom of this chart, though, the problem is that when there was the probation violation, these private sector sources relabeled that as a conviction for another burglary. So if you were to search for this person's name online, you'd think that they were committing new crimes and being convicted multiple times over this 3-year period, when in fact it was just a single conviction. So this is just one, like, kind of looking at the small data to understand the problems in the big data kind of moment. And I want to close by talking about the implications for people who find themselves trapped in this web. And the most consistent finding, and I interviewed people in Minnesota where I was doing my doctoral research. I interviewed people in New Jersey, interviewed people in New York State. And over and over, people would say, I know it's online, but I don't want to look for it. Or I need to find a job, but I'm not going to apply for a job that's going to require a background check. Daryl here says, I've looked myself up out of curiosity. I try to see what pops up. It's not a pretty sight. It tells me as long as I don't try for high-level jobs that I should be okay. I should fly under the radar. Tammy was thinking of applying for jobs, applied for 2 jobs, and then withdrew her applications because she was worried that the background check would continually report the single conviction that she had, that she was working on getting expunged at the time. And I think she's right. I mean, we know that companies sell data to one another. So her concern was if this restaurant were to pay a company to run the background check, then the background check exists, and then she gets an expungement, how will she ever be able to remedy that private report? And so she stopped applying for jobs. So these are really examples of people opting out of these institutional environments that all the research shows are exactly what we need for better public safety outcomes. We want people to have stable, safe employment. We want people to have jobs where they don't have to fly under the radar so that they can make sure their rights are being protected, right? So I think there's all sorts of down the line consequences that come from people trying to avoid these kind of institutional settings. And this also applies in the digital realm. Again, a very persistent theme that came up in interview after interview was that people just didn't want to look up what was online. It's sort of a learned helplessness approach. It's this idea that if I know there's nothing I can do about it, so why look it up? So you can read through these very similar quotes. I think Mariah's is helpful. I've never looked for it. It's too complicated. What can I do if I could do anything? And she's right that if people see it, they think you did it. It says you did something, but the truth is I didn't do anything. So this was a problem where her name was mixed up with other people's records and mugshots, and she was charged with a lot of things she was never convicted for, and she looked at it once and never looked again. Albert says, I deliberately avoid it. It's a horror story I don't want to relive. What good is my reaction to a website? What does that accomplish? So we get into this kind of problem, right, where there's this reverse sunshine effect. So we have all these public records laws. We have this idea that transparency is all about understanding government operations and watchdogging. But the data that we get is about other people. It's not about the government agencies to the same degree. So I can tell you, the home address of all these people that were arrested on a certain day in a certain jurisdiction, but I can often not tell you I cannot often give you aggregate data about the race of people that are being arrested in that same jurisdiction, or patterns that are assigned to different police officers, right? So I think sometimes the public, rightfully so, wants transparent access to government data, but what they're given is often about other people, not about the agency itself. Classic garbage in, garbage out problem. If we've got this unregulated, many different forms of data, they're kind of going into this middle ground and then being reproduced onto the internet, it's bad data. And so that just really makes things, I think, confusing for employers and decision makers, and very alienating for the people who don't have much control over their internet search results. These are very sticky labels. They don't go away with time. If you know how Google search works, the results that show up at the top of the list are the ones that people click on the most. Well, things like mugshots and arrest records are interesting to people. They click on them the most, and they continue to just kind of replicate. I'm concerned that this is a covert discrimination. We can regulate employers' use of criminal records. We can regulate landlords' use of records, but we can never regulate what people do in their own time on their phone when they're searching for people. And if you see something online, you don't have to tell the applicant that that's the reason they're not getting the job. And I, as we are moving towards another recession, these kind of informal screening mechanisms can be very harmful for people whose records are just stuck at the top of their search results. And like I said, when I first started, the disparate impact, I think, is doubled by the digital context, because those people that are able to kind of manage their digital reputation or crowd it with all sorts of great content and push the negative content down are often the people who are who are the most equipped to handle the justice system or to avoid having an arrest record in the first place. I'll give you a couple ideas about policy solutions, and then I'm gonna continue that conversation with Brian, and happy to answer your questions too. So expungement is very successul. It's really, I think we were actually going to do a poll, and I don't know if it's working or not. I think Brian's trying to do that. So expungement is sweeping the nation, and that's great to see. I'm just checking it out. Okay, there we go. Nice. The poll's in progress. Great. So I'm curious about people's thoughts on this. So yeah, expungement is sort of sweeping the nation. There's juvenile expungement, there's adult expungement, and having done much of my fieldwork at expungement clinics, people always have the same question during the Q&A, which is, how do I get it off the internet? And so I'm asking people to vote about whether if a juvenile record is sealed or expunged, it no longer shows up on the internet. I may have sort of led you to the answer, but I don't know if you can see the results yet, but you will shortly. And most people come in to the expungement clinics either with the assumption that it will disappear from everywhere, or the idea that they can sort of take that expungement paperwork and make sure that it disappears. And here's a screenshot of what's happening across the country with mostly adult level. So this is from the Collateral Consequences Resource Center. And again, it's just to show there's been this incredible kind of push for increasingly automated record sealing. And, should we be focusing on expungement? I think it's an important question to ask, given sort of the bad news I've been sharing the last 30 minutes. We have some limited and very positive research that expunging records does help people with employment. The issue with most of the data we have now is that it's about petition-based expungement. So it's including people who are able to kind of navigate through the expungement system and file the petition themselves. So the self-selection bias has been kind of difficult, I think, to manage. About 35 states have it. There's great variation in sealing, set aside, destroying, expunging, all sorts of different labels. There's all sorts of different eligibility requirements based on the offense, the time since the offense, age, if you have any outstanding fines and fees. So what do we know? Expungement has led to lower recidivism and improved employment, but there's been an incredibly low uptake rate. So in states that have expungement, there's just been it's like a lower than 10% of eligible people. In some states, it's much lower than that, have actually gotten the remedy. It can be slow, it can be expensive. One of the participants in my study just emailed me last Friday. His expungement process in New Jersey began in March 2018, and he got the expungement order last week. So this, of course, is the rationale for pushing for automated and algorithmic expungement. So does it work? Absolutely, it works for the things that expungement is intended for. So types of occupational licensing in particular, employment barriers, housing, anything that has a regulated screening process, expungement can be an excellent remedy. And, to get back to the poll though, we're not automating expungement compliance, right? And so the more and more expungements that happen as we go into automated systems, the more we're gonna have to figure out ways to hold private companies accountable and also give people an ability to sort of serve that expungement order to these different entities. And that can be very, very difficult to deploy at the large scale that automated expungement is rolling out. And I just want to remind people too that I think sometimes we forget that stigma is about more than getting a job, and getting a job is crucially important, and eliminating those barriers is crucially important. But when you talk to people, people also care about what their friends and family see when they search for their name on Google. They want to meet a new partner by online dating. They want to volunteer. And there's all these different ways that having a really, really intractable criminal identity saved on the internet can prevent you from actually participating in life the way that you want to. And then some final bullet points. We could insert privacy policy. I can talk about some recent rulings. New York State in the budget a couple of years ago with the mugshot, kind of the mugshot ban. There could be laws to restrict pre-conviction data, to restrict bulk downloads, to enforce these mugshot takedown laws, to regulate and enforce Fair Credit Reporting Act compliance, expand FCRA to those people search websites. And then there are, as much as these problems are caused by technology, technology may also give us some solutions. So give people access to their criminal records. We had 200 people in our study. The vast majority of them had never gotten to sit down and look at their own rap sheet, because in New Jersey, you have to pay $50 to go get it, right? And so we had a grant and could pay for people. They didn't have access to it. So what if we thought about criminal records the way we think about credit reports or medical history, where you have a right to look at it? There is some privacy around it. There's a way for you to fix a mistake on it. You know who to call if something doesn't look right. There's a single source. Streamlining and automating record sealing, I think, is super important. It should be paired with ways to make sure people know how to leverage or how to access the knowledge that their record is sealed, so that they can sort of use that in these employment contexts. Shifting the burden onto the state rather than the petitioner will help address that uptake gap, and that's where the technology will really come in to help with that. And then finally, the right to be forgotten. And we'll talk about this more conversationally, but I think, we have a lot of private companies that are making these really broad claims to being supportive of criminal legal reform, and yet use criminal justice system data to their benefit all the time without even noticing it. So we need to think about how Facebook and Google can step up and help people kind of reclaim their digital identities. I'm going to stop there. Thank you so much. I see that there's some questions to look at, and I look forward to hearing them.
Thank you so much, Sarah. So now we're going to move into a brief conversation portion with Sarah. So the first question that I have for you, so 2020 was a year of visually documented unrest. So after the riots that occurred on January 6th, many individuals took to the internet to identify people who had taken part and to report them to law enforcement. And this form of casual participation in digital punishment seems unprecedented. So how might this become a slippery slope for individuals, including youth, who are taking part in legitimate forms of social activism?
Yeah, I think, I just got an email from one of my colleagues that said, hey, did you see that, I think it's either the FBI or the Department of Justice website has this page where they're tracking everyone who was arrested on January 6th. And they asked me, they're like, is this digital punishment? I mean, where do you stand? And I think first and foremost, it was very interesting that the federal government was doing that at all, because they've been much less open than state agencies when it comes to sharing arrest records. There's federal litigation over whether or not the marshals had to release mugshots to reporters, and the marshals won that case. There was not a public interest in mugshots at the federal level the way that we think about it at the state level. And so I think my first kind of response to that is it's very interesting to see sort of how the federal government is operating differently after this event. And I think it's because it's an extraordinary event and not an ordinary one. Most criminal justice at the state level is very ordinary, right? It's sort of people being processing, often for low level stuff, day after day. So I think, kind of separating those two, the scale of the two things is probably important. But I also, I think that this kind of gets to that chilling effect. And I like how in your question, you're framing it around how do we make sure that people still participate in things, but not get sort of punished for it. And in my book, I write about digilantism. So people who have sort of felt that the justice system or more mainstream institutional avenues have not delivered the justice that they're seeking. So they use the internet to shame other people or to accuse other people because it kind of delivers that justice that they're seeking. And that's often rooted in feeling like the media and the government just, aren't getting it right, and that regular people can get it right. And I just wrote a chapter with a grad student at Rutgers, Katerina Kaplan, and we are arguing there that, it's starting to feel that public accusations between people are kind of more satisfying for a lot of folks than waiting for justice, which is slow and hidden and unevenly distributed. So yeah, I think, the events of the Capitol shine a light on all these issues. And certainly I think have made some folks in my circles think differently about, what are the limits to this, and when do we truly want privacy? When do we truly want transparency? So it's been challenging, but it's a great question.
Thank you. So in your book, you seem to suggest that digital punishment primarily affects communities of color. And if this is the case, what might this do to our already conflated historical understanding of race, class, and criminality? And how might we see this today?
Yeah, I think first there's some amazing researchers that have been asking these questions for years. Algorithms of Oppression by Safiya Noble is an excellent book on this. Brian Jefferson has a book very similar title to mine called Digitize and Punish, which is much more about kind of like the racialized carceral logics of digital surveillance. Virginia Eubanks has her excellent book, Automating Inequality. I think not only does it exacerbate the racist roots of the justice system, but I think this idea of kind of the legal cynicism and the kind of burden of surveillance and kind of heavy policing, all of that is really exacerbated by the digital trace because it just creates such a permanent record. But I think also it adds this visual element that is really salient. I mean, this is, American culture is obsessed with like all these crime shows and these mugshot websites do great. They get tons of traffic. And I think when you see sort of these racialized patterns in picture form, it just reinforces stereotypes of criminality and it really implies guilt well before a conviction. And that just undermines due process. That just sort of undermines the idea of the presumption of innocence.
So how might we realistically balance concerns over citizens' right to know with the deleterious impacts of digital punishment, particularly as it relates to youth? What might be some feasible policy options?
Yeah, so I think that, the first thing that we all need to do is to recognize exactly what's happening in our own states. So what are the laws that are governing access to juvenile records or any records? How are these laws actually being exercised in action? So often, people don't realize that their local jail is posting people's pictures. They don't realize that their clients might have all this stuff in the internet that they don't know how to cope with. So I think just like taking stock at the local level is really important. What is your newspaper doing? Have they made any statements about their use of pre-conviction data? So I think, that's sort of an important step that we can all take. I think that a policy solution that I sort of feel kind of low-hanging fruit in many states is to really recenter the role of the central repository. So if a lot of the data problems happen because police and courts and different jails are all producing data in silos, the BJS has long known this is a problem. This isn't brand new. We've just sort of lost the thread of this conversation in this like data-rich environment. But the state repository is built to centralize that data. If there's a way that there could be a single source that could make sure that the juvenile offenses on somebody's record stay sealed in this way and the adult offenses stay sealed in another way. If we could kind of fund and recenter the state repository as the gatekeeper, I think that would be really helpful for people. And then of course you could imagine policies that stem from that about employers' use of different records. Pennsylvania has an interesting law about the uses of Pennsylvania data by background checking companies. They hold the companies to these sort of data integrity standards that go above and beyond the Fair Credit Reporting Act. And so I think cleaning and managing the data from a central source would be enormously helpful for a lot of people, especially for those who are concerned that their juvenile records are being following them into their adult stages.
So one final question I have for this portion is, what can youth justice practitioners and policymakers do to begin addressing digital punishment and its negative consequences, including stigma?
Yeah, it's a great question. And so I'll reiterate how important it is to just understand the local practices of your police department, of your local sheriff's department, the local jail. Any sort of contact point with the justice system is sort of fair game for a data disclosure. So just understand in your context how things are unfolding, and then how secondary sources use that data once it's released. The biggest policy shift in this arena has been newspapers deciding, especially since last summer, that they didn't want to be in the mugshot racket anymore. The Boston Globe announced a new initiative just, I think, Friday or Saturday, where you can petition to have old news stories about an old arrest that never led to a conviction, some sort of embarrassing story about you. You can go through a process with their editorial office to have that content taken down. A newspaper in Cleveland's been doing that already for 2 years. So take stock, I think, is the most important thing. Encourage people to know what's out there. I mean, this digital avoidance really just sort of lets problems linger for people, right? And so thinking about digital literacy is also being having sort of the resources and strength to see what's online. If there is any sort of court order that you can get for the people that you work with, whether it's an expungement or sealing order, or it's the court disposition paperwork that something's been dismissed, you can try to go directly to different sources and ask them to take content down, and increasingly private websites are doing that. So really, I think making sure that people you work with have a sense of what their criminal record is, and that you have a sense of where criminal justice data is being generated and where it's being shared in your county and in your state.
Awesome, thank you. And with that, I think we'll move into our audience Q&A portion. But before I get to audience questions, I have a question for the audience. So it's another poll. Let me see if I can.
And I will say, yes, the last poll, 81% of you are correct. So if your record is sealed or expunged, it is not automatically taken down from other places. And this has sort of been one of those kind of sticky parts of expungement law that is going to still take some work on behalf of these private companies to start to comply.
So one question I had for the audience members is, how worried are you about your digital reputation? So are you very worried? You regularly check your Google search results? Somewhat, you think about it occasionally but don't monitor your digital reputation? Or you're not at all worried, people Google themselves? So if y'all could just take a second to let us know where you are in terms of how worried you are about your digital reputation. And it seems like people are somewhat concerned. And so I'm just going to let that go for another second. But while that's going, I'm going to ask a question from an audience member. So are there any efforts to correct errors in data? And who's responsible for cleaning the data after it's been made public?
Yeah, wow, great question. So this is, it's like the classic runaround where like each kind of entity sort of says the one before them is who should be held responsible. And often people feel that going to the court is the best place to try to figure out, the full disposition of a case and to kind of get the proper timeline. But you have to really go to the court, because if you go to a court website, you're going to be confronted with all these disclaimers that the court says we actually don't know if this is accurate or not. We can't guarantee that it's accurate. You've got to come down here and talk to us first. And then, for the person in my study who just had a 3-year-long expungement petition, one of the reasons it was held up is that he got a disposition paperwork from the probation office, and they accidentally switched a 3 in his court docket number to a 2, a typo. So of course the other courts no one could figure out what it was. It was all mixed up. And so it was this like very small data error. But again, everyone, there's almost like an administrative qualified immunity, right? That, people aren't doing this to be malicious. The person that wrote that letter didn't mean to write the 3 instead of the 2. But for this study participant, he was just so frustrated because he had no idea where else to go. I mean, he's like, I can't drive to this many courthouses. Like it just, and then COVID happened, which really complicated things. So when it comes to the accuracy, it really kind of can depend on exactly what type of information you want to get. If it's about a probation term ending, then you go to the probation office. I mean, it's really about going to the source. And I think this is why, in an idealized system, the repository could be that place where people could go. And in some states, there are processes for you. In New York, there's a process to correct an error in your state rap sheet if you've gotten access to it. But of course, you need to make sure that the courts then fix that error as well. So I'll reiterate my credit report, medical report analogy. These are administrative records that have profound consequences for how people can live their lives. And so accuracy is really paramount. It just can be a really messy process.
Thank you. So it seems like most people are somewhat concerned about their digital reputation. 68%, with the second being they're not at all worried. 23% said they're not at all worried, and 9% said that they're very worried about their digital reputation. So the next Q&A question, one audience member asked if you can say more about how errors happen, like traffic convictions can be misconstrued, and how the private criminal background checks can lead to misinformation because of poor formatting of the information.
That is spot on. Yeah, that's really, is that the end of the rest of the question?
There was a second part to that.
Okay.
In terms of the issues of expungement, they said that there should be a better way to handle them in terms of public information.
Yes, I agree with that. I'll start with the expungement piece. I mean, it's really, I'm very much for the burden to be passed on to the state to expunge records rather than a petitioner, for obvious reasons. And the tricky part is, though, if your record's been automatically sealed, you're not notified. So most of the models in the 10 or so states that have some sort of automation, the state just does it, and you don't even know that it's happened. You should, if you read the statute, you should know if you're eligible, and you can assume that it's been sealed. But I think one thing for states to think about is how can we make sure that people can maybe contact the court and get a copy of that expungement order so that they can bring it to the job interview just in case that shows up on the background check. I mean, again, like putting people's records into their own hands is really the only way you can start to combat these hundreds of different data sources, is that you can confidently say, this is supposed to be sealed and I have proof. Of course, there's research that shows that any sort of mark, any sort of criminal justice contact, the experimental study that we did showed that arrest that didn't lead to conviction still had a really serious consequence or somewhat serious consequence for employment outcomes. So it's hard to know if the signaling through the expungement order could also be harmful. But in general, I think that's one way to make sure that automated expungement is still giving like the individual person the opportunity to update those background checks. Yeah, and the formatting, I mean, when I started in this field, after college, we were doing a lot of like employer education campaigns and like, how do you read a criminal record? What is a misdemeanor? What's a felony? And I hope that those efforts are still happening, but it sure is hard to read these records. And criminal justice is local. States have their own. In New Jersey, we don't use the phrase misdemeanor or felony, right? We use indictable offense and disorderly person. I mean, that's confusing. Some of the people who are in my study have rap sheets that have charges from the 90s, and it just says cocaine. It doesn't say, possession. It doesn't, because just the way that data was entered then. So to answer the very first part of the question, that's really where error is introduced. It's at sort of the data entry level, whether that's digitizing old records and trying to automate that and doing it quickly, or it's just the person who's typing things in. And so it's kind of scary because one very small error can sort of replicate across somebody's life.
And I think we have time for one last question. So keeping the issues in mind that you discussed today, how can we use data to best serve you to encounter the juvenile justice system? Are you aware of any jurisdictions that have successfully implemented sort of a unique identifier that connects the data of individuals together without identifying them to allow policymakers to make informed decisions?
That's a really good question. And I think I want to think about it before giving a really specific answer. I'll make sure that the slides are available and some of the organizations that are really tracking that there's like a juvenile criminal record report card and things like that. You can really look at state by state. And the Collateral Consequences Resource Center has incredible state by state guides for how data are handled. And Brian, can you remind me the second part of that question?
Yeah, are you aware of any jurisdictions that have successfully implemented a unique identifier that connects the data of individuals together without identifying them to allow policymakers to make better informed decisions?
Yeah, I guess I'll just answer that with the kind of I think for the researchers here, a bigger question that is circulating, which is, how do we study the justice system if records are being sealed, and sort of, how do we maybe study, recidivism at the individual level, but also how do we track the sentencing patterns of individual judges or individual DA's offices. And so, I think we're kind of at this crossroads where we have to think about, what we use justice system data for. Is it for tracking people? Is it for background checks? Is it to answer questions about how police behave? And then we should really be pushing our agencies to produce data that answer those questions, rather than what we have now, which is a really piecemeal and kind of wholesale data dump.
Great. Well, thank you so much, Sarah. I'd like to thank you on behalf of YJI and everyone in attendance today for presenting this work on digital criminal records and their attendant issues and considerations. And I think I can speak for everyone when I say that this is an incredibly interesting topic with timely implications, particularly with the advent of these newer forms of technology. But before we go, I'd like to ask if you have any parting words of wisdom for us.
Right. I think this has been on my mind a lot, especially since the murder of George Floyd, and just seeing how the conversation has changed. I think a lot of people want to be on the right side, and a lot of private companies want to be on the right side of this moment. And I encourage everyone to take pause and think about the ways that we do kind of legitimize the justice system, even while we might be criticizing it. So if your company is using background checks, well, what for? Is it because it's job related? Is it because it's truly a safety issue? Or are we just gotten so accustomed to a criminal record being a really convenient proxy to decide somebody's worth? And if so, how might we change our thinking about that? I do think a lot of this is sort of changing our own perspective on the use of the record. A mugshot does not demonstrate the worth of a person, right? It shows who a police officer decided to arrest. So I encourage everyone to sort of take maybe the way that they've been changing their thinking about the legal system overall and how we can make it better, and making sure you're including these sort of casual and I think secondhand uses of criminal records that we've gotten really accustomed to doing.
Thank you. So before we go, I do have a few announcements and items that I'd like to put on everyone's radar. So the next session of our Lunch and Learn series will be on February 23rd at 12 p.m. Eastern Time, and we'll be hosting Dina Thompson, who is the Executive Director of the Erie County Restorative Justice Coalition, and she'll be speaking to us about restorative justice practices and youth. So be on the lookout for more information regarding that webinar. And the YJI also has an ongoing podcast series called Let's Talk About Youth Justice. The inaugural episode features a conversation with Dr. Timothy McCuddy, who spoke with me about traditional bullying, cyberbullying, and issues related to both. And Alicia will be putting the link for the podcast episode in the chat section, I believe. And we're also producing a new episode of this series this semester, so be on the lookout for that as well. And finally, the New York State Permanent Judicial Commission on Justice for Children, in partnership with the YJI, invites you to Social Justice for Our Youth, presented by Dr. Monique Morris. Dr. Morris is an award-winning author and social justice scholar with 3 decades of experience in the areas of education, civil rights, and juvenile and social justice. She is also the executive producer and co-writer for the critically acclaimed documentary Push Out: The Criminalization of Black Girls in Schools. The virtual event will be held on Thursday, February 25th from 12 p.m. to 1 p.m. Eastern Time, and we will place the link to register for this event in the chat. And shortly after we finish here, we will be sending a survey to you all via email. If you have the time, please complete the survey, as it allows you to provide further feedback and questions for us. And this information will be used to improve future webinar sessions. And the survey should take no longer than about 5 minutes. Finally, if you've not already done so, feel free to connect with us on Facebook, Instagram, Twitter, and LinkedIn. And the links to those accounts can be found on our website. And just a reminder that the views expressed here are those of the presenter and do not necessarily reflect the views of the New York State Youth Justice Institute. And in closing, I just want to thank you all for taking part in this YJI Lunch and Learn session. We hope that you've gained something from this webinar and that you continue to think about what Dr. Lageson has presented today. We also look forward to seeing you at future YJI events. So thanks again, everybody, and have a great rest of your week.